Okay, good morning, everyone. All right, in chambers, we went over a number of objections, and I made some rulings. So let's start with the defendant's objections to some of the exhibits that the state wanted to put in. Mr. Ng, did you want to address that?
Thank you, Your Honor. Mr. Gray and I had a chance to go over almost 400 exhibits over the weekend, and we raised objections to several of them for the court's review. I understand the court is making a ruling that some of the exhibits are admissible and some may not be, but we did make an objection to exhibits 3 and 4, 239, 240, 241, which are Spark of Life exhibits. We object to the Spark of Life testimony. We understand the case law, but we respectfully disagree with the Supreme Court's case law on that. Already only one photograph is necessary, and that's why we object to those. We also objected to...
Okay, let me put on the record what my ruling was on that. The state wanted to put in 5 Spark of Life photographs. Minnesota law, of course, allows for that. I decided that the state could put in 3 of them, not the 5.
We also made several objections, Your Honor, to the autopsy photographs and photographs of Mr. Wright's body at the scene. Those would be 41, 113, 120, 125, 175. It's our view that the photographs of a naked body of Mr. Wright were unnecessary to prove that he was shot by a pistol. In particular, some of the photographs with his eyes open are prejudicial and not terribly probative of the issue, which was his cause of death, which we're not disputing that it was caused by a gunshot wound. And we therefore objected to those exhibits.
Would the state like to put its position on the record?
Thank you, Your Honor. We understood the objections to be about certain photographs with the eyes being open. That is a condition of a dead body on occasion. The autopsy, of course, is very relevant to the issues in the case and all of the injuries, and it is simply a photograph of the accurate condition of the body at the time and necessary for the medical examiner's testimony about the cause of death. We therefore believe that the photographs are relevant and necessary, and we opposed on that basis.
All right, I overruled the defense objections to the autopsy photographs. It's necessary for purposes of describing the injuries. Mr. Ng?
We had another issue that I'd like to put on the record, Your Honor. The passenger of Mr. Wright will be testifying today, and the defense seeks to admit exhibit labeled 1004, which is a packet of Xanax tablets. And the purpose of our admissibility, or the reason for the admissibility of the evidence, is that what happened here is that during the stop, Mr. Wright handed a package of Xanax tablets to his passenger and told her to hide the tablets. She then hid the tablets in her perineum. She was taken to the hospital, and at the hospital, a detective from Brooklyn Center was made to sit with her, which is customary, and during her conversation with the passenger, she told the detective, Mona Pearson, that Mr. Wright had given her the pills and that she hid the pills. We believe this evidence is relevant to show Mr. Wright's consciousness. I mean, is that term we're banding about in the case, that he was about to flee, that he knew he had an arrest warrant, didn't want the pills to be found on him because once he was in the jail, they would be discovered. We believe this is probative evidence, and it is consistent with our cross-examination of the passenger. We also believe that her statements, the passenger statements, are against her own penal interest because these are Xanax tablets that are not prescribed to anybody and she should not have had. And therefore, when when she confessed to Mona Pearson, she was confessing against her own interests. So for all those reasons, we sought to introduce the evidence of this green photograph and also to cross-examine the passenger accordingly.
Would the state like to be heard on its position?
I do, Your Honor. Thank you. It's our position, well, first of all, that the exhibit marked 1004, if the court wants to receive that in the court file only to preserve for the record, should it become an issue on appeal, should not be filed as a public document because it is not an exhibit in the trial. It's just for the appellate record. Secondly, Your Honor, the issue in this case, as you know, concerns the state of mind of Officer Potter when these acts were committed. This court has already ruled that evidence of drugs that were not known to Officer Potter is not admissible, or relevant, and certainly prejudicial. And that's exactly what this photograph and this line of inquiry is intended to do, is backdoor that through, to impugn Mr. Wright based on this sort of backdoor approach, and that's why it's being brought out now as well, I believe. So we asked the court to follow its previous ruling and its order of October 27, that this evidence is not relevant and is highly prejudicial and likely to mislead and confuse the jury. It simply has no relevance to Ms. Potter's actions. Any claim that it has some relevance to Mr. Wright's actions is technically, I think, irrelevant. His actions are caught on camera, and Officer Potter will presumably testify about why she did what she did, but certainly there's evidence of what happened, and so it's irrelevant for that issue, for that reason as well. So we understand the court is, well, I guess I'll just say we, on those bases, objected to it.
Okay. Yes, I rule that would not be admitted as evidence. We'll make it a court exhibit should the case be appealed. I previously ruled that any type of evidence with respect to bad behavior on the part of Mr. Wright would not be admissible unless Officer Potter was aware of it at the time of the incident. The key issue in this case was Ms. Potter's state of mind when this happened, and that the Xanax has nothing to do with that issue and would only serve to mislead or confuse the jury. Okay, were there others?
No, Your Honor, but to preserve the record, we will offer as a court exhibit 1004, and we also offer from yesterday court exhibit 1005, which is a photograph of Dante Wright pointing a gun into a mirror. The court has ruled that we can't admit those. How would the court prefer that we file these? Would you prefer we file these under seal or provide them to you?
We'll make them a court exhibit, and you can provide them to Mr. Kramer.
Thank you.
Okay, were there other ones, Mr. Ng?
No, Your Honor.
Okay.
Your Honor,
Yes.
if I may briefly, with respect to the exhibit that has now been identified as Court Exhibit 1005, that was from our discussion, I believe, on Monday about an area of cross-examination that the defense wanted to go into, and the court had made a ruling at that time that that photograph would not be allowed. I can't remember if we made a record about this on Monday, but that's what the Court Exhibit 1005 is. And again, I would ask that that not be filed publicly, but made part of the court file for appellate review.
Right, we dealt with that yesterday, actually, but did not make a record of it. So that will not be admitted, but will be a court exhibit. Okay, anything further from the defense?
No, Your Honor.
Okay, is there anything from the state?
Your Honor, we did also deal with objections to Exhibits 29, 30, and 31, defense objections, and we would, I guess just while we're making these records, we might as well that those are, well, 29 is a short video of the passenger, and the other 2 are photographs of her injuries. The defense did object to those, and the court overruled the objections.
Yes, I'm going to allow the video of the passenger and the video showing her injuries, or the photograph. Okay.
Excuse me, Your Honor.
Yes.
With respect to our, the state's objections to our exhibits, we also have the right under the Sixth Amendment to present a defense. And I want to raise that as an issue for appeal if we go there.
Okay.
So we're being denied by the not being able to use these exhibits to present a defense under the Sixth Amendment to the United States Constitution. Thank you.
And, Your Honor, it's well-known case law that while they have a defendant has a Sixth Amendment right to defend himself, they have to do so within the rules of evidence that this court and courts adopt. So it's not a free-form right, but I understand the counsel's preserving that for the record. But that's the full story.
Okay. Is there anything further that we need to deal with before we get the jury in here?
Your Honor, we did raise 2 matters in chambers, and I would like to make a quick record of it if I could.
Sure.
So we had raised a concern that counsel might represent to the jury that if, that the state has to prove Ms. Potter did not, too many double negatives, that the state has to prove Ms. Potter knew she had a handgun in her hand. And if the state can prove that, she is not guilty. We think that's a misstatement of the law, and therefore saying that to the jury would be a misstatement of law to them, inconsistent with the court's own instructions. And we brought that up ahead of time because we didn't want to interrupt for the first time bringing it to the court for an objection. And our understanding of the court's position on this is that the defense can argue that as a theory, as a factual theory, but we will take issue and argue to the jury that that is an incorrect, if it's stated in those absolute terms, that we will dispute that with the jury and, of course, direct them to the court's instructions, which will be an accurate statement of the law. And I don't know if you want me to move on to the next one or...
Okay. I had ruled that the defense is entitled to argue its theory of the case. And the state and the defense both have conflicting views of what their theories are, but I'm not going to constrain the defense from making their arguments. And they, in fact, do have an expert that's going to talk about slip and capture. So, and I've previously ruled that that expert testimony is admissible. Okay, anything further? All right. Yes?
We did talk about also the attempts by the defense to offer expert opinions, or what amounted to expert opinions, on the reasonable use of force through fact witnesses. Our understanding of the court's ruling is that the court will allow some inquiry about officers' opinions about whether their training would have allowed them to do what Ms. Potter did, I guess. So we're still, we still take objection to that, Your Honor, as both unqualified and unnoticed expert opinion.
Okay, the officers that will be testifying can testify that they were trained on the use of tasers. They can talk about their training. They are officers and they know about that area, and so I'm not going to preclude them from making those statements when they testify. Okay, anything further from the state?
No, Your Honor, thank you.
Anything further from the defense? Okay. Is counsel ready for the jury?
Your Honor, we would request a short recess.
Oh, okay. How short a recess?
We just need to set up, Your Honor.
Okay. Why don't we take like 5 minutes? Would that be enough? Okay, we'll take 5. Mm-hmm. Yes, I'm ready for the jury. Good morning, members of the jury. Please be seated. All right. Jury members, you've been selected to serve as the jury in this case. Before continuing with the trial, an oath will be administered by my clerk. In recognition of the extremely important task that you will be undertaking, I'm going to ask that everyone in the courtroom stand up, with the exception of the court reporter. And if you will please stand up and raise your right hand.
Do you affirm that you will be attentive during this trial and follow the instructions of the judge so that you may reach a fair and just verdict, that you will not discuss this case with anyone until submitted to you for deliberation, and will keep your verdict secret until it is delivered to the court? If so, please say I do.
All right, you may be seated. Jury members, you have been selected to serve in this criminal case because the parties believe that you would be fair and impartial jurors to decide this case. It is important that you be able to hear and see everything that takes place during the trial. If you have difficulty hearing or understanding what a witness is saying, or if a witness or an attorney should block your view, please raise your hand immediately so that we can correct the problem. The state of Minnesota has charged this defendant with the crime of manslaughter in the first degree and manslaughter in the second degree. To these charges, Ms. Potter has entered a plea of not guilty. By her plea, the defendant denies the charges which have been made against her and places upon the state of Minnesota the burden of proving defendant's guilt beyond a reasonable doubt. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until the defendant has been proven guilty beyond a reasonable doubt. That the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you as in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove her innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The trial in this case is about to begin. Here are some basic rules about your job as a juror. Your job will be to decide what the facts are in this case by considering the evidence. As judge, I will apply the rules of evidence and tell you what you can and cannot consider as evidence. Well, what is evidence? Evidence is what the witnesses say on the stand. This is called testimony. Evidence can be items like photographs and documents. These items are called exhibits. Evidence can be facts that the parties agree on. This agreement is called a stipulation. What is not evidence? The following is not evidence. Nothing the attorneys say during the trial, including opening statements and closing arguments, is evidence. However, listen to any statements the attorneys make. The statements are made to help you better understand the evidence. The attorney's questions are not evidence. The witness's answers are. Objections are not evidence. Attorneys may object if they think a question or answer is against the rules. I will sustain the objection if I think it is against the rules and you should ignore this question or answer. If I overrule the objection, the answer is evidence like the rest of the witness's testimony. You cannot consider anything you hear or learn about this case outside this courtroom. You must follow the instructions on what you can consider as evidence. You may take notes during the trial, but you do not have to take but you're not required to take notes. Don't let your note-taking distract you. The most important thing for you to do is to listen to the testimony as you hear it. The notes must stay in the courtroom during the trial. You should leave your pen and your notepads on your desks. They'll be there in the morning when you come back and after you come back from lunch. Use your notes as an aid to your memory and not as a substitute for it. Fit the notes in with your total recollection of the facts. A written note does not necessarily make a piece of evidence more important whether you or another juror wrote it down. If at some point in the trial you run out of paper or your pen is no longer working, please alert my staff and we'll take care of that. Wait until you've heard all of the evidence before you make up your mind. Your best guide is your own good judgment, experience, and common sense. You must decide which testimony to believe and how much weight to give it. In deciding this, you may consider the following. Will a witness gain or lose anything if the case is decided a certain way? What is the witness's relationship to the parties? How did a witness learn the facts? How did she or he know, remember, and tell the facts? What was his or her manner? What was his or her age or experience? Does the witness seem honest and sincere? Was the witness frank and direct? Is the testimony reasonable compared with other evidence? And are there any other factors that bear on believability and weight? You must decide the facts. You and only you can decide the facts. Do not take anything I say or do as a sign of what your verdict should be. Once the facts are decided, you must follow the law. You must follow the law even if you don't agree with it. Now, I want to give you a few instructions about your conduct as jurors. Do not let outsiders influence you. Do not discuss this case with other jury members during the trial. You will have plenty of time to do this at the end of the trial once you have heard all the evidence and I've excused you to the jury room with my instructions and the verdict forms. Do not talk to anyone involved in this case. This includes the defendant, the lawyers, and the witnesses. If anyone tries to discuss this case with you outside the courtroom, report this to me or one of my staff. When you go home during the trial, do not talk to your family, friends, or others about the case. You may tell them that you are a juror on a criminal case, and that is all that you should tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, MySpace, LinkedIn, Google+, YouTube, or any other social networking sites about this trial. Do not visit any chat rooms where this case may be discussed. Do not read or listen to news reports in magazines or in newspapers or on the radio, television, podcasts, or any other media about the case. Do not do your own investigation. Don't ask people about the case. Don't visit any of the locations mentioned in the trial. Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media. Keep an open mind until you have heard and seen all the evidence. Remember, you cannot consider anything you hear or learn about this case outside this courtroom. If you don't follow these instructions, you may jeopardize the trial. This may require that we start all over again, and we really don't want to do that. If you become aware that another juror may have violated these rules, you must report it to me or one of my staff. I know that this can be a difficult thing to do, but in order to preserve the fairness that is guaranteed to everyone involved, it is very important that you do so. Please take note of the chair you are sitting in and keep the same chair throughout the trial. When reporting for jury duty in the morning and returning to the courthouse after lunch, you need to report to the courtroom waiting room that you were in today. Do not communicate with anyone in the hallway if you happen to be out there who is not a member of this jury about any matter. These rules will apply until I dismiss you from the case. I may also repeat these rules when we take a break and when you leave at the end of the day. I don't do this to insult you, but in this age of electronic communication, it's a natural impulse for us to all look things up, to discuss things that we're doing with our friends and family, and post things on the internet. It is not, however, an impulse we can follow in this trial. Once we've completed this trial and you've given your verdict, and I have discharged you from the case, you will be free to do any research you choose and to share your experiences if you choose to do so. If you have a question I want to remind you again, you want to communicate with the court, please alert my staff. During the trial, of course, if you have any difficulty seeing or hearing, please raise your hand or make my staff aware of that. I will be instructing you on the law more fully after the testimony has been completed. I want to give you a broad outline of what this trial will look like. First of all, the attorneys will be making their opening statements. The purpose of the opening statement is not to argue about the evidence. The attorney's goal is just to give you a bird's eye view of what that attorney believes the evidence will show. After opening statements, the state is going to proceed first with its case in chief. After each state witness is called, the defense has a right to cross-examine. After all state's witnesses are called, the defense has the right to call witnesses as well, and the state has a right to cross-examine defense witnesses. Remember that the defendant is not required to prove her innocence. She is not required to call any witnesses. After the defense has called its witnesses, I will be giving you, the state may have rebuttal witnesses, and then I will give you your instructions of law that you are to apply in rendering your verdict. Following that, the attorneys will make their final arguments to you. Okay. Would the state like to proceed with this opening statement?
Yes, Your Honor, thank you. Police officers occupy unique positions of power and responsibility in our society. They hold positions of public trust, and they commit themselves to public service. They are accountable to the communities that they serve. And Brooklyn Center police officers are no exception. Their fundamental duty is to protect the sanctity of life. To do this job, the job of a Brooklyn Center police officer, they promise to safeguard lives. They promise to serve and protect, to maintain calm and develop self-restraint, and to be constantly mindful of the welfare of others. They promise never to employ unnecessary force or abuse. This is the oath of a Brooklyn Center police officer. I will never betray my badge, my integrity, my character, or the public interest. I will always have the courage to hold myself and others accountable for our actions. This is the standard they hold themselves to, and they take an oath to do so. Their duty to their badge and to the community is to protect life, not to take life. Now, they are also required to abide by a code of ethics. This serves as a type of compact or an agreement between each of the officers and the public that they serve. It sets forth what the community, what the public should expect from each and every one of them. It affirms that the badge is a symbol of public faith and public trust, and that the officers are each individually responsible for their own professional performance. And they each vow to take every opportunity to enhance and improve the level of their knowledge and competence. These officers carry deadly weapons every day on the job, and they receive extensive training in order to carry them. They're trained professionals. They're entrusted by the public with these weapons. Every day they put on their uniforms and they go to work, and they go to work out on the streets of our communities. They're trained to do this job. They're trained to interact with people of all walks of life, trained to interact with people in crisis, trained to interact with people on their worst days, trained to interact with people who may very well not want to interact with them at all. And every day that they go to work, they're required to be alert, attentive, and capable of performing their duties. Every day that they strap on that duty belt with their guns and their tasers, they have to be alert, attentive, and capable. And every day they do this, we entrust them with our lives. These officers have the responsibility to be mindful and attentive and acutely aware of the weapons that they carry and the risks associated with those weapons. They have the responsibility to follow their duty and their training when it comes to those weapons, and they have the responsibility to carry those weapons and use those weapons appropriately. We trust them not to use those weapons rashly or recklessly, and we expect not to be shot dead on the street for no reason. We expect them not to betray their badge, and we expect them to uphold their oath. We trust them to know wrong from right and left from right. This case is about an officer who knew not to get it dead wrong, but she failed to get it right. This case is about the defendant, Kimberly Potter, betraying her badge and betraying her oath and betraying her position of public trust. And on April 11th of this year, she betrayed a 20-year-old kid. She pulled out her firearm, she pointed it at his chest, and she shot and killed Dante Wright. Now, the defendant was a 26-year veteran of the Brooklyn Center Police Force. For 26 years, she went out on the streets with the obligation to serve and protect. She had those same duties and those same responsibilities as every other Brooklyn Center police officer. That same fundamental duty to protect the sanctity of life and to safeguard life. She was bound by the same rules, the same policies, and she was bound by the same code of ethics. And you'll hear about the Brooklyn Center policies. We'll touch on those a little bit, and you'll hear about the defendant's training on things like the use of force, the use of firearms, and the use of a taser. And you'll hear she was trained not to use unnecessary force. She was trained not to shoot an unarmed driver. She was trained not to fire into a vehicle. And she was also trained not to use her taser on a fleeing suspect. And she was trained to be aware of the differences between her gun and her taser. And importantly, she was also trained about the risks of pulling the wrong weapon, and that drawing and firing the wrong weapon could kill someone. Now you'll learn about her firearm. It's a 9mm Glock handgun. And you'll hear about how the Brooklyn Center Police Department uses hollow point ammunition as their standard ammunition. That's the kind of ammunition that expands on impact. It peels back the metal in layers when it hits its target. Now this peeling action, it can slow down a bullet, but it can also cause extensive damage to the body in that way. This is a common type of ammunition used by law enforcement. And not only will you hear about the ammunition and the firearm, you'll hear about her taser, a Taser 7. Now a taser is a conducted energy weapon that shoots out 2 probes when you press the trigger. And those probes are supposed to attach to the skin and deliver an electric shock. And they do this because they're designed to incapacitate someone through something called neuromuscular incapacitation. And basically what that means is your muscle seize up so you can't move. And they can also be used to inflict pain. And you'll hear about the weapons from the witnesses in this case. But every day that the defendant, Kimberly Potter, went to work, she strapped on her duty belt with her gun and her taser and all of the other options available to her on that belt. And every day she put on her duty belt, she carried her weapons in the same way. She carried her Glock, her firearm, on her right side. The defendant is right-handed. She carried it on her right side, her dominant side. And she carried her taser on her left side, her non-dominant side, something you might also hear referred to as her reaction side in some of these policies. She was trained to carry her weapons in this way, and she was trained on how to use them and how not to use them. And you will hear about that training, and you will learn that she had firearm training and taser training every single year. She had to be requalified on her firearm every year. She had to be tested and recertified on her taser every year in order to carry it. And she had additional training just a month before this incident. On March 2nd of 2021, she passed all the requirements to be certified on this Taser 7. Now, before I cover all the details of the policies and what happened with her training, I'm going to talk a little bit about Dante Wright and the events of April 11th of this year. Dante Wright was Katie Bryant and Aubrey Wright's first child together. He was their first son as a couple, and he lived at home with his parents and his 2 younger sisters, Diamond and Destiny. And he had 6 siblings in total. It was a large, blended family. A large family with a lot of love to go around. Dante Wright also had dreams for his future. When he was little, he wanted to be a professional basketball player. Who doesn't? And as he got older, he had a number of jobs in retail, food service. And you'll hear that he spent some time working with his dad at the same shoe store. And not long before his death, he had plans to enroll in a trade school to pursue a career at Summit Academy. Now, Dante Wright also had a son of his own, Dante Jr. Dante Jr. was 1 year old at the time of this incident, a toddler, now fatherless. And on April 11th, Dante Wright himself was just 20 years old, just out of his teens, still had a close relationship with his mother. And he had a new baby boy, a loving family, and his whole adult life ahead of him. Now, on April 11th, Dante Wright went to his parents' house. His mother, Katie Bryant, was watching his son, Junior, on that day. And Dante Wright had recently been given the family car, a white Buick, as his own. And he was excited about that. And after getting this car, that was now his own, he wanted to get a car wash. That's what his plan was for April 11th. So his mom, Katie Bryant, gave him some money, and he left with his girlfriend, Elena Albrecht Payton, in the car. He headed out, and he later called his mom to figure out where he should go, which car wash was the right one. But he didn't make it. He never made it to the car wash that day. And he never made it home. Why? Because he was shot dead in his car in the middle of the day by the defendant. Now, what was the defendant doing on April 11th? On April 11th, the defendant had been a police officer for longer than Dante Wright had been alive. On April 11th, the defendant was acting as a field training officer, FTO. She was training in a new officer whose name is Officer Lucky. And on April 11th, while out on patrol, the defendant and Officer Lucky saw an air freshener, a little tree, hanging from the rearview mirror of Dante Wright's car. And they decided to stop the vehicle. Yes, for the air freshener. But as they stopped the car, they also noticed the tabs were expired. But this was a run-of-the-mill traffic stop. This is the kind of stop that happens every day. So after they pulled over this white Buick that Dante Wright was driving, it was Officer Lucky, the trainee, who initially approached the car. Officer Lucky approached the car. He made contact with Dante Wright, and the defendant stayed back in the squad and observed from a distance. Officer Lucky interacted with Dante Wright. He explained the reason for the stop, and Dante Wright gave Officer Lucky his information. He gave him his name. He gave him his full name, including his middle name, his date of birth, his address, his brother's name. He answered all the questions that were asked of him. And then Officer Lucky took that information back to the squad car and talked to the defendant. And when Officer Lucky returned to the squad car, what had scared 20-year-old Dante Wright do? He called his mom. And in these COVID times, the tabs had not been updated. He didn't have an up-to-date license. He didn't have a proper insurance card. And he was trying to figure out the situation. So he called his mom for help. And back at the squad car, Officer Lucky acknowledged to the defendant that Dante Wright had been forthcoming with him. And he told the defendant that he believed that Dante Wright was telling him the truth. He then ran the name through their system, and the defendant, who's his trainer corrected him. The defendant corrected Officer Lucky when he entered the name in the wrong way. And once they ran the name, the defendant and Officer Lucky found, yes, in fact, that Dante Wright had an outstanding warrant for a failure to appear on a gross misdemeanor weapons violation. So in the squad car, the defendant and Officer Lucky, they discussed their plan, and they decided to arrest Dante Wright on that warrant. And the defendant in the squad corrected Officer Lucky a second time when he code 4'd himself too early. Code 4 being just giving the all clear before he had that information completely from their system on the warrant. And while they're having this conversation, Sergeant Johnson, another Brooklyn Center Police Department officer, came on scene. And he approached the squad, talked to Officer Lucky and the defendant about what was going on. They filled him in. They did not express concerns for their safety. They did not decide to approach the car with guns drawn. They simply decided to arrest Dante Wright on the warrant. This was nothing out of the ordinary for the defendant, a 26-year veteran of the Brooklyn Center Police Department. And on this day, she was training Officer Lucky. She was responsible for showing him the proper way to do things as a Brooklyn Center police officer. And she did not direct Officer Lucky to approach the vehicle any differently than he had before. So Officer Lucky walked back to the driver's side of the Buick where Dante Wright was. And the defendant got out of the squad but stood back to watch. Officer Lucky asked Dante Wright to put his phone on the dash, asked him to step out of the car, and Dante Wright complied. Now, when Officer Lucky began to handcuff Dante Wright and told him that there was a warrant and that he was under arrest, that was when scared Dante tried to get away. He tried to get back in the car. He tried to leave. Dante Wright was unarmed. He had no weapon. He was not violent. He did not threaten the officers in any way. He didn't reach for anything. He got in the car, put his hands on the steering wheel. He didn't come at the officers, didn't throw any punches, didn't kick anyone. He just pulled away, got back in the car, while Officer Lucky was trying to maintain his grip on Dante Wright's clothing to pull him back out. So Dante puts his hands on the steering wheel, he puts his foot down on the brake, he does the things that you do to get ready to drive a car. At that point, Officer Lucky reaches in from the driver's side and tries to turn off the car, and meanwhile, Sergeant Johnson, who has approached on the passenger side, grabs Dante Wright's right arm, right hand, from the passenger side of the vehicle to try to get control of him. But he kept his feet planted firmly on the ground. He tried to turn off the car from that side, tried to get Dante Wright under control. So Officer Lucky and Sergeant Johnson continued to engage. Now at that point, the defendant approached the vehicle behind Officer Lucky. She intervened and she interfered. Officer Lucky was her trainee and she was the FTO. So she was the one who determined how this stop would go. She was the 26-year veteran. She was the officer in charge. And it was her job to show Officer Lucky how it's done. And what did she show him? She showed him how to kill someone. Now, as soon as she gets involved, she escalates the situation. She acts rashly and impetuously. She draws her firearm. She draws it with her right hand from the right side of her duty belt, where she's always kept her gun. She draws it with her finger on the trigger, and she points it directly at Dante Wright's chest. Now, at the same time, there are two other officers, as you can see here, with hands on or interacting with Dante Wright. Officer Lucky is to the front of her and sometimes to the side, and Sergeant Johnson on the other side of the vehicle. And Dante Wright's girlfriend, Elena Albrecht Payton, is in the passenger seat, right next to him. They're all within a few feet of the muzzle of the defendant's gun. Now, the defendant says, "I'll tase you." And then she says again, "I'll tase you," a second time. And then, "Taser, taser, taser," which prompts the officers to let go of Dante's arms and then disengage. But she points the gun at Dante for more than 1, 2, 3, 4, 5.5 seconds. Aims, pulls the trigger, and fires into his chest. And when she pulled that trigger, these people were all still around him, including these two other officers, Officer Lucky and Sergeant Johnson on the other side, and Elena Albrecht Payton in the passenger seat. And when she pulls that trigger, she fires directly under Officer Lucky's face, with Officer Lucky's arm reaching over the top of where her gun is. When she pulls that trigger, Dante Wright is in the driver's seat of that car. He has his foot off and on the brake, and the car is running on a busy street in the middle of the day. She did all this despite her training. She had been trained year after year after year to prevent this kind of thing from happening, but she did it anyway. Now, after she shot Dante Wright, the defendant admitted she had messed up big time. Here's what she said. Shit, I just shot him. I grabbed the wrong fucking gun and I shot him. I'm going to go to prison and I killed a boy. Now, I'm going to play for you now a short video clip of some of the evidence that you'll see in this case. It's a composite. It's two videos on the screen at the same time. One is a clip from the defendant's own body-worn camera, and one is the squad camera. They're synced up for you so you can see. But this is just a very small portion of what you'll see in this trial. This just shows the few seconds around this incident.
Sam Stefano. You got a warrant.
I'm not doing that. Don't. You said stop, bro. Don't do it. Don't do it. Hey, don't.
I'll tase you! I'll tase you! Taser, taser, taser!
Ah, he shot me.
Oh, my shit! I just shot him.
Get in the car.
Yes! I grabbed the wrong fucking gun! I shot him! Oh my god! Oh my god!
Members of the jury, there is no do-over when you walk the streets with a loaded firearm. When you're entrusted with a deadly weapon as part of your job, there's no do-over when you take a young man's life. Now, this was exactly what she had been trained for years to prevent. But on April 11th, she betrayed her badge and she failed Dante Wright. Now, after the defendant shot him, Dante Wright's car traveled about a block down the street. It crossed the median and it hit another vehicle that was traveling in the opposite direction. And you'll hear from Patricia Lundgren, who was driving that other vehicle. She and her husband were coming down the road when they were hit by Dante Wright's car. And you'll also hear from Elena Albrecht Payton, the passenger who was riding with Dante Wright. And she'll tell you about the crash and the injuries she suffered. Now, you'll also see and hear about the fact that after the defendant shot Dante Wright and the car crashed a block away, she didn't do anything to help him. She didn't call for assistance. She didn't render aid. She didn't communicate any information about what had happened to her fellow officers who were responding. And when they showed up down the block, they didn't know that Dante Wright had been shot. They didn't know that the defendant had shot him. And they didn't know what they were dealing with at all. So almost 10 minutes later, a small army of officers approach with guns drawn and drag Dante Wright's dead body out of the car at gunpoint. And the defendant did nothing. You'll also hear from paramedics that Dante Wright was declared dead on scene. And then the BCA arrived to investigate the matter. And the medical examiner's office came and they collected the body. There was no bringing him back. You'll hear from the medical examiner, the assistant medical examiner in this case, who conducted the autopsy, Dr. Jackson. And he'll tell you about his examination, his autopsy procedure, and his findings in this case. And you'll see photos of Dante Wright's injuries. And you'll see that gunshot wound that tore through his heart. Dr. Jackson will also tell you that he recovered a projectile from Dante Wright's body, the bullet, after it ripped through his insides and got lodged in his chest wall. And he'll describe for you the condition that it was in, that peeling back of that metal, and how that's consistent with a hollow point bullet. And he'll also tell you about his findings on cause and manner of death. The cause of Mr. Wright's death was a gunshot wound to the chest, and the manner of Mr. Wright's death was homicide. You'll also hear from a use of force expert in this case, who will tell you about the use of the weapons at issue here. And he'll tell you that it was objectively unreasonable for the defendant to use her firearm. And he'll tell you that even the use of the taser would have been unwise under these circumstances. Members of the jury, I'd like to take a moment to discuss what this case is not about. It's not about intent to kill. That's not why you're here today.
Objection argumentative.
The objection is overruled. You may.
Thank you, Your Honor. The judge will give you the law, and she'll give you instructions on the law to apply at the end of this case. But intent is not an element of any of the charges at issue here, and it's not something that the state will have to prove. That the defendant didn't intend to kill Mr. Wright or that she didn't mean to shoot him with her gun, if you hear those things, they have nothing to do with the charges at hand. Indeed, if the defendant had meant to do these things, if she had meant to shoot her gun into Dante Wright's body, we would be talking about intentional murder and not the charges at hand. And that's not the case you have before you. The defendant is not charged with intentional murder. No one will say that she wanted him dead. No one will say that she wanted this to happen. And no one is even saying that she meant to shoot him with her gun. But the evidence will show that's what she did. She fired her gun at point-blank range into Dante Wright's chest. She unholstered her weapon. She drew it. She aimed it. She pointed it directly at Dante Wright. And she pulled the trigger and she shot him in the chest. And she did those things without bothering to confirm what was in her hand. Firing a weapon, blindly assuming it to be a taser, after drawing the wrong weapon from the wrong side. She did all those things with a gun. That's what she actually did. A gun loaded with hollow point bullets. The kind that expand on impact. The kind that tear up someone's insides. She did this with a firearm that she was issued, that was part of her job, that she was entrusted to carry in the course of her duties, to serve and protect. So as a result of all of this, the state has charged 2 crimes. First-degree manslaughter and second-degree manslaughter. And again, the law you will apply will come from the judge at the end of this case. But these charges are in the realm of recklessness and culpable negligence. Those terms will be defined for you by the court later. But the law in Minnesota criminalizes all kinds of reckless conduct. Things like reckless driving, reckless child endangerment, reckless handling of a firearm, and in certain cases, manslaughter. And that is what this case is about. It's about the reckless handling of a firearm, and it's about the disregard of known risks. It's about an officer who knew she could kill someone if she got it wrong, but she failed to make sure she got it right. You may also hear at some point during this case, this incident might be described as an unfortunate mistake or a tragic accident. Or that because the defendant didn't know she had a gun in her hand, that this should be called an accident and not a crime. And again, the law you will apply will come from the judge. Those are the instructions that you will follow. But that's simply not the case,
Counsel,
members of the jury.
please stick to the facts.
This case is also not about Dante Wright. Dante Wright.
Just his argument, I checked. She's given her opening statement, now she's arguing her case.
I'd like you to just stick with a bird's eye view of the facts that you think will go in, and no argument, counsel.
Thank you, Your Honor. You'll hear about the training. You'll hear about the policies. There will be evidence of all of those things presented in this case. And I'm going to highlight some of those things for you. The defendant's history of training over a 26-year period as a Brooklyn Center police officer will be evidence in this case that you will have to consider in the connection with the charges at issue. Now, over the course of her career, the defendant received extensive training on a variety of topics, year in and year out. She had training on firearms, training on tasers, training on use of force, and that included all types of things. Readiness to use force, scenario-based training, so real-life type situations where you have to react under stress, choose the right type of weapon, choose the appropriate response. She was trained to do all this under stressful conditions. She was also trained to maintain calm, manage stress, and make those decisions in the moment, out on the street. But the evidence will show that she flouted her training and she flouted policy. I'm going to give you a highlight of some of those policies and trainings. Now, when it comes to firearms, she was required to successfully complete training on her firearm every year. She had to be requalified, in addition to the quarterly training she received. And she was also instructed by policy that she should not unnecessarily display or handle any firearm. That's part of the policy. The use of force policy instructs officers they shall only use the amount of force that reasonably appears necessary in a particular situation. There's also policy on moving vehicles and how officers should use or not use their firearms in those situations. And that policy indicates that an officer should only discharge a firearm at a moving vehicle or its occupants if deadly force other than the vehicle is directed at the officers or others. Policy also says that officers should not utilize firearms during an ongoing pursuit unless the conditions and circumstances meet the requirements for deadly force. There's also policy on de-escalation, that officers should use non-violent strategies and techniques to decrease the intensity of a situation, to improve decision-making, to improve communication, and to reduce the need for force. Now, in addition to training on policy and training on firearms and use of force, you'll hear about policy on tasers. And the policy on tasers for Brooklyn Center is known as conducted energy device policy. And policy says that the purpose of the taser is to control violent suspects as opposed to fleeing suspects. And that appropriate use should result in fewer serious injuries to both officers and suspects. And you will see that mere flight from a pursuing officer is not good cause for the use of a taser. And you will also learn that Brooklyn Center policy says that the use of a taser should be avoided where collateral injury might result. Collateral injury, meaning someone else could get hurt or killed. And that includes on individuals who are operating vehicles. You'll also hear that tasers require training as well in order to carry them. That in order to carry a taser, officers have to complete successfully their department training. Now you'll learn that policy also dictates how those should be carried in a reaction side holster. Again, that's the non-dominant side, on the opposite side of the duty weapon. It also requires that those items be distinctly marked, that they look different, and that officers should not hold them both at the same time. And we'll talk about some of those differences, and you'll hear about them during the course of the trial. Now, you'll see in this picture the defendant's taser, Taser 7, up top in yellow, and the Glock 9mm handgun pictured at the bottom. And you'll hear about the differences between these two items. The color, for one, Well, it sounds like stating the obvious, perhaps. The Taser is bright yellow, the Glock is black. The differences in weight you will learn about. Now, the Taser weighs 0.94 pounds, and the Glock, the firearm, when loaded with 17 rounds of ammunition, it weighs 2.11 pounds. That's more than twice as much. Now, you'll also hear about the differences in safety, in the display, and the laser that comes on the Taser, and the holster location. And I'll talk about those things too. Now, when it comes to the safety, a safety is just a mechanism or a button of some kind, a switch in some cases, that makes a weapon inoperable. And the Taser 7 has a safety on the side that you have to flip up right there in order to arm the device. It has to be engaged. And the Glock, the firearm, has no safety switch like that. It has a trigger safety. So basically, you pull the trigger on the Glock and it fires. Now, when it comes to the display, well, when you flip up the safety on a Taser, it arms the device. It means it's ready to use. And when you do that, when that switch is lifted up, three things happen. A display screen comes on the back of the Taser. Green and red laser lights appear coming out of the front of the Taser, and they appear on the target that you're aiming at. And the flashlight also turns on. And that display screen is pictured here on the back of the Taser. It faces the operator who's holding it. The person holding the Taser sees this display screen when it's on. And the lasers, the top laser comes out of the top cartridge, a green laser light that appears on the target showing where that top prong would deploy. And depending on which cartridge you're using, one of two red laser lights appears. But there's a green light and a red light that appear on the target when you aim the Taser after it's been armed. Now, you'll also see for yourselves and hear about the defendant's duty belt that holds her gun and her Taser holsters. Now, on the right of the screen is the Taser in its holster. The Taser holster is made of plastic. It has a latch right here that has to be depressed. You have to push down on a button to release the Taser from its holster. You press down on that button and then rock the Taser backward. The Taser has to lean back, rock back, to be pulled up and out of the holster. Now, the firearm holster, which is on the left side here, empty in this photograph, is made of a soft leather-like material, and it has a snap that just releases and the gun comes straight out. Now, as you saw before, Taser and firearms have to be holstered in different ways pursuant to policy. The policy requires that the Taser be carried on the reaction side, the non-dominant side. And the firearm, the gun, is carried on the dominant side. In this case, the defendant's right hand side is where she kept her gun. Her left side is where she kept her Taser. Now, you'll hear about that requirement. The policy requires that officers carry those weapons on separate sides of their body. Officers are given a choice when it comes to how those Tasers are positioned on their non-dominant side. Now, the choice is a cross draw or a straight draw. Now, for a cross draw, the officers use their right hand, reach over the body with the right hand to pull out the Taser. In that situation, as pictured in the top here, the butt of the grip points forward to make that cross motion so that the officer would pull that Taser with that right hand in a case as pictured here. Now, the defendant had her holster set up in a straight draw. The added protection of having the taser come out with her left hand. When a taser is positioned on the left side of the body in a straight draw, the butt of the gun points backward, and the officer has to rock the taser out and pull it up with the left hand. Straight draw taser is to be drawn with the left hand. The defendant had her duty belt and her holsters positioned so that she would have to draw her taser with her left hand. Now, the defendant had chosen this setup and this additional protection in the way that she carried, and she had done this consistently for years, and you'll see evidence of that. She carried in a straight draw position in 2016, left side, straight draw. 2017, left side, straight draw. 2018, left side, straight draw. 2019, left side, straight draw. 2020, again, left side, straight draw, including April 11th of this year, left side, straight draw. She had her taser positioned on her left side, as required by policy, with the added protection of straight draw, pulling it with her left hand. Her Glock, her firearm, again, by policy, on the right side of her duty belt. So the only weapon she draws with her right hand is her gun, not her taser. You'll hear about policy on targeting when it comes to the taser as well. Policy says that officers should target lower center mass, but they should avoid the head, the neck, the chest, and the groin, sensitive areas of the body. And you'll also hear about taser training and how the policy requires training, and you'll hear about the training that they go through as well. But the training is required to include performing reaction hand draws or cross draws, which is not applicable to her, to reduce the possibility of accidentally drawing and firing a firearm. Policy requires that when they are trained, they practice. They practice drawing that taser with that left hand with the straight draw. It's required by policy. You'll see some of those records, the records of the defendant's training. Every year she received classroom training, hands-on training, and instruction, practice on this taser, on the tasers that she was issued, and that included the recent certification. In 2015, she was trained and certified. In 2016, she was trained and certified. In 2017 and 2018, she was trained and certified. And in addition, she had to acknowledge that she had received the product warnings and that she had understood those warnings at the time that she was recertified on her taser. And she acknowledged receiving them every year she was trained. This is 2019 and 2020, and you'll see those records. And again, in that most recent training, March 2nd, 2021, she once again acknowledged receiving and understanding those product warnings. Now these trainings, like the one on March 2nd, also include reviewing the PowerPoint presentations, demonstrating safe handling, performing de-escalation arcs, basically being able to use these tasers in safe ways. And again, on March 2nd, 2021, she indicated that she understood and received the warnings, the Axon product warning. Axon is just the parent company for Taser. She understood those warnings. And what did those warnings say? They said, confusing a handgun with a CEW, a taser, could result in death or serious injury. learn the differences in the physical feel and holstering characteristics between your CEW, taser, and your handgun to help avoid confusion. Always follow your agency's guidance and training. And those PowerPoints in that training that she went through continued to remind officers of those risks. Those PowerPoints that she had to sit through to be certified every year included that tasers are not risk-free. They can cause death or serious injury. The PowerPoints themselves set forth that the course attendees, the officers, had to acknowledge that they had read and understood that taser warning that you just saw. They included that tasers are serious weapons and should be treated as such. This was all part of the training. And over the years, they also talked about the benefits and the risks with respect to the way that you carry your taser. And they specifically had in their training that the benefits of carrying a taser on the non-dominant side had associated issues. That includes, let me rephrase. If you carry your taser on the dominant side, if you're right-handed and you carry your taser on the dominant side, they had instructed their trainees there's a higher risk of weapon confusion. They talked about the risk of weapon confusion in those trainings. They explained that there were known incidents of shootings by mistaken weapon confusion. This was part of the training going back at least as early as 2016. They trained that you could kill someone, and there were incidents of shootings when you made the mistake and pulled the wrong weapon. And so they explained why it makes sense to carry your taser on the other side of your body. And they direct officers to refer to your department's tactical experts and make your own policy on how to carry, holster, and deploy. They instructed about the known risks. Those risks also included instruction on risks of injury to people operating vehicles or machinery, and risks if someone is tased in the heart or chest area. Those trainings also included smart use considerations. And those smart use considerations explain that if there's no immediate safety risk, slow down and consider alternative force options. And they explain that physical resistance alone does not equal an immediate safety risk. The training materials themselves tell you to reevaluate. The training materials also tell officers to be aware, to be careful, and to be aware of stress and how stress can influence these situations. And they instruct that officers have been accused of using excessive taser exposures due to stress or distractions. Be alert and avoid potential distractions. This is part of the training. And they talk about where to target, where you should aim the taser if you're using it. The trainings say to target the back, that the back is the most preferred target area. And that's because it contains larger muscle groups and reduces the risk of hitting sensitive body areas. And it tells you on the front, you should, if you have to tase at the front, tase below the chest, split the belt line, increase that distance between those probes so you don't tase near the heart and you don't tase the chest. And the reason for that is there are cardiac risks associated with tasing someone in the chest. So the training materials say, target the back, avoid the chest, avoid the heart region. And the taser training materials also say that historically, over time, these deployments have been most effective from 7 to 15 feet away. Use this distance where you can to have a higher hit probability, good probe spread, if you want these items to be effective and to achieve that neuromuscular incapacitation. Because they may not work if you don't have the appropriate distance between your probes. The Taser training materials also talk about a spark or functionality test. The training materials say that a full 5-second spark or functionality test should be conducted once every 24 hours. That's in the training materials. It's also in the policy. And you'll hear evidence that the defendant failed to spark test her taser for the 2 days prior to this incident. You'll hear that she didn't do that, even though it was required by policy. And even these slides on spark testing explain that you should be aware of potential stress. And over again, throughout the years, every time she's seeing these slides, she's seeing that the tasers are not risk-free. That repeated messaging, big letters, read the warnings, understand them. Understand that tasers can cause death or serious injury. Understand the risks of weapons confusion. But the evidence will show that the defendant flouted that training, and she disregarded her fundamental duty to safeguard life. I killed a boy. I killed a boy. Those were the defendant's words. That's what she said after she did what she did. On April 11th of this year, the defendant shot and killed Dante Wright, a 20-year-old who had an air freshener hanging from his rearview mirror. A kid in a Heartbreaker jean jacket. But on April 11th of this year, Dante Wright was not the heartbreaker. It was Dante Wright who had his heart broken. And it was the defendant who broke Dante Wright's heart when she fired a hollow point bullet straight into his chest. Thank you.
Okay, members of the jury, we're going to take a 20-minute break before the defense has an opportunity to do an opening statement. Okay, so 20 minutes. Okay, a couple of things. There are a media person here. I do not want you trying to talk to the families while you're in the courtroom, all right? Also, please don't leave until the jury leaves the courtroom. And that applies to the families as well as the attorneys and Ms. Potter, okay? All right, are you ready for the jury? All right. Thanks, Deputy. Okay, welcome back, members of the jury. Please be seated. All right, the defense may present its opening statement.
May it please the court, Mr. Frank and your team, Mr. Gray, Ms. Montgomery, former Officer Potter, and her family, her husband, sister-in-law, and brother, members of the jury. She said, "I'll tase you. I'll tase you." The language was direct, it was clear, it was unmistakable. And all Mr. Wright had to do was stop. He was told he was arrested on a warrant. He resisted. She said, "I'll tase you." And all he had to do was surrender. But that wasn't his plan. He continued on with her struggle. And 5 seconds later, she says, "Taser, taser, taser." And you're going to remember those 3 words for the rest of your life. And when she's saying those 3 words, ladies and gentlemen of the jury, you have to know from the facts what she is seeing. Okay? Because what she is seeing is that her partner, Sergeant Johnson, is in the car. He's a tall individual. He's going to testify probably tomorrow. But he's in the car restraining the gear shift so that Mr. Wright can't escape. And she knows that if he's not stopped, Mr. Wright's not stopped, he's about to drive away with a police officer dangling from his car. And she knows, and she'll tell you this, that when she says taser, 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 if she does nothing, Mr. Wright drives away and either substantially harms Sergeant Johnson or more likely he kills them. So when she says, taser, 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 there's one last pause. The facts will show you. Mr. Wright can stop. All he has to do is stop, and he'd be with us. But he goes. She can't let him leave because he's going to kill her partner. And so she does taser, 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 and she pulls the trigger believing that it was a taser. For why else would she say it? And immediately, upon pulling the trigger a single time, which is the training for tasers, the training for gun is to pull twice, she realizes what has happened, much to her everlasting and unending regret. She made a mistake. This was an accident. She's a human being. But she had to do what she had to do to prevent a death to a fellow officer, too. Well, before I start on the facts, and there are quite a bit more details to this case than you just heard about over the last hour, I'd like to introduce myself once again. It's a great honor to be here. It's a great privilege to be a lawyer in America, I think, and to be able to stand before you in this distinguished court in a case of this magnitude. And we are all about to engage in the great experiment that is called the American democracy, the central feature of which is a jury trial, where, according to the Constitution, if a citizen is accused of crime, her peers get to decide what the facts are and render a just verdict. It's humbling to be here, but a great honor to be her voice, along with Mr. Gray, to talk to you, to answer to the questions she wants us to ask, and to present the evidence she wants us to present for her, and to finally argue for her at the end of the case, which will be done by Mr. Gray. It's a historic process that we're all engaged in, and I know you'll appreciate it, but it's been going on for hundreds of years, to over 200 years, in the American effort to be fair. And there's something sacred about what we're trying to accomplish here. You're making an everlasting decision about a human being. And there's hardly any greater responsibility than that. Well, this is an opening statement. It's meant for the defense and the state to give you a roadmap or an overview of the case. It's my chance to tell you what the facts are, many of which were left out. So here's what I'm going to do in the next half hour. I'm going to introduce the police officers to you, because they're just not there for a second. They have lives. They have careers, and you should know more about them. So I'll talk about Kimberly Potter and her life and her career. I'll talk about Sergeant Michael Johnson, and I'll talk about Anthony Lucky. I'll give you just an overview of who they are, which you should know about. Then I'll follow that by talking about what happened here. Why he was arrested. This case isn't about a license tab. It's about a bench warrant and a guy that had a harassment order and violent conduct on his part. So we'll go in second by second on what happened here and what she saw, because she'll tell you that next week. But I want you to be in mind and mindful of what she saw. And then after we talk about the incident, I'll tell you about the other witnesses we're going to call to buttress and support our defense, the experts and the lay witnesses alike, and then we'll be ready to go. So I want you to hang with me for a half hour here. That's where I'm going to go. So let's start with the three officers. Well, first, Kimberly Potter. She's 49 years old. born in 1972, 4 kids in her household. She had one of these experiences as a kid that is memorable. One day in her grade school class, a police officer named Michael McGee came to talk about bicycle safety. And it is amazing what influence an adult might have on a child at any particular time, but she enjoyed the talk, and it dawned on her that she might want to be a police officer. Just by the mere fact this officer came to her class. She pursued the interest in high school. She was in Explorers, which is kind of the teenager grouping that allows kids that age to experience police work to see if they might be interested. And by the time she had graduated from high school, Totino Grace, by the way, which is in the northern suburbs, Catholic high school, maybe you are familiar with it, she had decided to be a police officer. And what she wanted to do was get a BA and then pursue her career. So she enrolled at St. Mary's University in Winona and started down there in 1990 and got a degree in criminal justice and sociology, which are the standard majors for police officers. She graduated in 3.5 years. She was an industrious student, worked really hard. And then she started applying for work in the community. She got a job at the Anoka Regional Treatment Facility, but she wanted to get in with the police force. So she applied and was hired in 1995 to work for Brooklyn Center Police Department as a patrol officer. And she'll tell you one of the proudest days of her life was to have her dad pin the badge on her so that she could be a police officer. Around the same time, she married her husband, Jeff, who's the fellow with the dark suit. And they have 2 kids. One's in the Marine Corps now, and one plays the Division I hockey in the Dakotas. And they raise their family in the Champlin area. She started out her career as a patrol officer. She always wanted to be on the street. She took a special interest in domestic abuse victims, which will come into play in a minute. She became a part of the Brooklyn Center Domestic Abuse Task Force. She was really interested in women who were victimized by men and subject to the violence of men occasionally, and she shepherded the women through the court system, became their mentors, made sure they were treated fairly. She had a talent for negotiation. She was on the hostage negotiation team for Brooklyn Center. She was on the crisis team. She was an FTO, asked to be an FTO, which is an honor as well to train police officers. And then this day that we're going to talk about in a moment, she was the FTO, Field Training Officer. And one of her greatest achievements, she'll tell you, is that she is on the honor guard for police officers who die in the line of duty. She is the one among several who carry the caskets. Police officers who are shot. And every officer will tell you that the most dangerous thing a police officer will do is respond to a traffic stop or an act of domestic violence. And everybody that makes a stop knows that something may go wrong. So that's her career. That's who she is. And over the course of 26 years, she never fired a gun. She never fired one shot. She never fired her taser. She never had to. She was good at de-escalating everything, and here that's what she's trying to do. I'll tase you, which is another way of saying, please stop, so I don't have to hurt you. Please stop. So that's who she is. She'll tell you that. Sergeant Johnson is on the scene. He's 41. He started the force in 2005. He became a member of the SWAT team, and you'll see that he is an imposing guy. He's 6'2", 6'3". He's on the SWAT team because of his physicality. SWAT teams, he'll explain to you, go into houses to arrest people, do search warrants and are engaged in the activities designed to arrest people who don't want to be arrested, and anything that's involving a dangerous course of action, the SWAT team is often called. He'll describe that to you. But the fact of the matter is, SWAT team members tend to be fearless because they take the most risks. And on this day, he was the guy who opened the passenger car door and stayed in the car. And he was the guy that she wanted to save. So that's Sergeant Johnson. He's a patrol sergeant. He's her supervisor. He evaluates her. And he's on duty that day. He gets the radio call and he arrives. Finally, we have Anthony Lucky, who is the young one of the bunch, but old in terms of experience. Mr. Lucky's in his 20s, Officer Lucky's in his 20s. He grew up in Brooklyn Park, which of course is next to Brooklyn Center. Graduated from high school there. He too will tell you that somewhere along the line when he was 7 or 8, he decided to be a police officer. After high school, he went to junior college for 2 years, Rasmussen. Got certified. You need a 2-year degree to be a police officer, 4-year, 2-year. And got his boards and started to become a police officer. His first job was up in Mille Lacs for the Mille Lacs band up in Mille Lacs Lake. The geography was a little tough. That's not quite where he wanted to be. He had a job in Gaylord, Minnesota, small town north, south and west of here. And then he applied to where he always wanted to be, which was Brooklyn Center. And Brooklyn Center was right next to where he lived. He knows the streets, he'll tell you. He knows the people. He knows the culture. He has intuitions about what is occurring because he grew up here. And in a sense, wait for him to testify as well. So those are the 3 people that really know what happened here. Let me go now into April 11th. On this day, Officer Lucky is supervised, as we said, by former Officer Potter. They start the shift. It's a Sunday. It's non-eventful. Nothing is happening much on a Sunday in April in Brooklyn Center, but they're on routine patrol. An FTO supervises the new police officer. Officer Lucky just started in February of this year. And he's driving along and he sees a white GM Buick in a turn lane. The signals are opposite. Instead of turning left, there's a signal to turn right. His curiosity is piqued. He decides to follow the car. It's his decision. As he follows the car, he runs the plate. He notes that the tabs are expired. He sees a Christmas tree hanging from the mirror. But this case isn't about tabs. It's not about Christmas trees. He has a right to stop. He makes the decision. It's his own decision. She joins it. She doesn't oppose it. And he stops the car. And you're going to see a much longer video as we go through here. So he does what he's trained to do. He walks up to the car door. The window comes down. He immediately notices the odor of marijuana. They didn't tell you that last hour. He sees marijuana shake inside the car. He asks for a license. Mr. Wright, who is driving the car, has no license. He can't give him one. His license is suspended. He asks for insurance. Officer Lucky does, because in Minnesota, to drive a car, you got to have insurance. And the reason you have insurance is that should you get into a crash, that the victims of your crash can be compensated. And the only insurance card that Mr. Wright could produce was something 4 years old in a different name. So we've got some flags here going on. It's not anything about the tabs any longer. It's about someone who shouldn't be driving a car at all. Lucky goes back to the car. They get in. He runs a warrant check. Standard. There are different databases that can be used to run a warrants check. If you've ever stopped, this has happened to you as well. But so he runs a check, and you'll hear the audio of it, and there's a warrant for him. So this changes the equation. The warrant is for a gun charge. A gun charge. It's a gross misdemeanor, and this causes Lucky, who lives in the area, to be alarmed, because he knows from his own personal experience from this area that a substantial percentage of people driving in Brooklyn Center have guns in their car. He'll estimate it's up to 40%. That may be high, but that's for his own anecdotal experience. But there's a substantial chance, he'll tell you, that there's now a gun in the car because the guy's got a gun warrant. And he'll tell you he thought there was a substantial chance Wright had a gun either on his person or in the left container of the car in the doorway or in the console, which is where you hide the guns. Okay. He's alerted. So they run more checks, though. And what they didn't tell you an hour ago is there was a harassment order against Mr. Wright. A female had secured an order for protection against him because he had been violent against her. So we have guns. We have someone who's accused Mr. Wright of being violent, and a court had ordered him to stay away from her. We have marijuana in the car. He can't drive the car away. He can't be allowed to leave. So Lucky goes back to the car and says, they have a conversation here. And the conclusion he drew was that he had to be arrested on the warrant. A court of law directed him to arrest him. It has nothing to do with a license tab. It has to do with a court order from this district. So the plan is to go to the door and arrest him. But they also have to know who the female is in the car, because Lucky knows, Officer Potter knows that with restraining orders and harassment orders, sometimes the girlfriend or the friend who gets the order reconciles with the defendant. And they have to find out who she is to see if she is in danger. This is standard police work. No fault can be had for the strategy here. So Lucky walks up to the door, tells him, Mr. Wright, to get out. He can't arrest him inside the car. So he directs him to get out, and about the same time, all three of them say, you're under arrest. And Johnson, by this time, has conferred. He knows what the situation is, too. So there's an arrest warrant for a gun. In hindsight, I suppose, they could have taken Mr. Wright further back. But all these officers will say that sometimes they arrest at the doorway. But the plan was to cuff him and then figure out what to do. They had to cuff him, recheck the warrant, recheck the woman, and then figure out what to do. This is all legitimate. This is all legitimate police work. And all Mr. Wright had to do was surrender on the warrant, which he had to have known about. That's all he had to do. So he gets him out of the car, Lucky does. And then you hear on the videotape, which you'll hear many times, is he turns Dante Wright to the car, tries to get his arms back, which is what he's supposed to do, and then Wright starts to tense up. And Lucky says, don't tense up. Don't tense up. Don't do it, bro, I think is the language that you'll hear. So we have someone who's supposed to surrender and doesn't want to surrender. And he gets back in the car, and it's chaotic. It's fast moving. This is really quick. Mr. Wright is extremely fast. He knows exactly what he wants to do, and that is escape. So he twists and turns back in the car. And at this point, Johnson enters the car. Johnson holds, as I say, the gear shift, so he can't drive. Lucky's trying to hang on. And at this point, he has to be stopped. He can't just drive away because the police officers know that fleeing a police officer is also a felony. And fleeing at a dangerous speed, which you saw in the video, is a dangerous felony. It's a crime of violence. They also know they can't let him go. They can't. The court has said arrest him. I'll tase you, I'll tase you, I'll tase you, she says. It's clear, it's direct, it's rooted in her hostage crisis training. She announces what's going to happen to him. She hopes, as I tell you, that he will comply, be arrested. She repeats it twice. I'll tase you, I tase you, and there's 5 seconds. And then, as I told you, she sees Johnson, whose location was key to the case, because if this guy drives away, he's dead. He's dead. So the moment, what happens, she shouts, taser, 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 and one of the issues for you, or the key issue in the case for you, is what was her conscious thought as to whether or not she had a taser in her arm or whether or not she had a gun.
An objection, Your Honor, to argumentative.
The objection is overruled.
The evidence will show you, in her own testimony and in your intuition after watching the video 10 times, is that she believed that she possessed a taser. That's why she said taser, taser, taser. She didn't say gun, gun, gun. And if she believed that she had a taser, which she did, then she did not have an awareness of possessing a gun. You know, the crimes alleged here are going to be defined by Judge Chu at the end of the trial, but it's just not shooting somebody. That's not the crime. It's being consciously aware of some kind of fact.
An objection, Your Honor. Time law.
All right, Counselor, please stick to the facts.
Okay. Well, as you look at the case, you decide whether, when she said taser, 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 she meant something else. You decide. And that's why we're here, essentially. We have that dispute. So that takes care of what happened. You know who's the testimony is going to be. Now I want to tell you who our other witnesses are going to be before you, and then we'll get going on the case. We're going to call several witnesses. The first one will be Timothy Gannon. He's the police chief, former police chief of Brooklyn Center. He was starting at Brooklyn Center in 1994, about the same time former Officer Potter did. His rise through the department was a different course. He was on the SWAT team. He became a sergeant quite quickly, and then he became a commander. There are 3 commanders and then a police chief, and then eventually he became the police chief of Brooklyn Center, and he's going to testify first. He's a veteran of the Iraq wars. He's got a BA. He's a wealth of experience. He's been in over 100 critical instances in his life where shots were fired. He's been in danger himself. And he'll testify about the training that Brooklyn Center police officers take, and he'll testify that he's seen the videotape himself. Different views of the tape now as it become more produced in the discovery, and he'll say that given the position of Johnson's body in the car, it was consistent with Officer Potter's training to not only shoot a taser, she certainly could do that, consistent with what she was trained to do, but she could have also shot him. which was not intention, but she could have shot him, given the fact that Johnson almost died. But that will be his testimony. He'll also tell you a little bit about being in these traumatic critical incidents, is what they're called in police training and the police world. And he'll tell you that he's been in, as I say, 100, but he'll also tell you that there's certain inability to recall events that happen so quickly and they're so violent. And part of Officer Potter's testimony will be a lack of recall as to some details in this. She's got most of them, but some details are gone. And that does happen during critical instances involving trauma. So he'll tell you a little bit more about that. We're going to call next a fellow from Missouri named Steve Iams, I-J-A-M-S. He's a 29-year veteran of police work, and he's going to testify as to the reasonable use of a taser. There's a question here. They're going to present their own expert named Stoughton, and we will present an expert to you in the form of Iams, Steve Iams, that the use of the taser was certainly legitimate. It was appropriate. There was enough distance. The central claim, factual dispute that you're going to have to decide is whether the car was moving or whether, in other words, Dante Wright was in control of the car. The testimony will be that the car was not moving, that he wasn't in control of the car, and that was the purpose of Johnson being there. And you'll have testimony when someone says taser, 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 that's consistent with the training, then everyone jumps back so as not to be shocked by the taser itself. So when Officer Potter shouted taser, 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 that's when Johnson and Lucky moved back. And the fact that she shouted taser, taser, taser saved Johnson's life. So that's Steve Iams. He'll come in. We've got another officer named Colleen Fricky who was with Kimberly Potter that night, and she'll show you videotape to give you a sense of the profound remorse and the emotional impact this has had on her. And she'll show you a video of Kimberly Potter huddled in the corner of Brooklyn Center Police Station. Her grief and regret was inconsolable. But grief and regret is not a crime either, or reflective of one. We're going to call character witnesses for her, people who've known her, police officers, friends from the family, all ages, to say that she has a good reputation for being peaceful and law-abiding, so that you know that this is something that is way out of the ordinary for her. And finally, we're going to answer the question that some of you had of, well, if you're a police officer for 29 years and trained so well, why should something like this happen? And so we will be calling a fellow named Lawrence Miller from Boca Raton, Florida. He's a PhD in psychology with an expertise in traumatic incidences and police work, violence. And he's going to talk to you about how it is that we do one thing while meaning to do another. And it's called in the literature an action error. And he'll come in Friday morning, a week from this Friday. And he'll talk about the routine kind of action errors that we all experience. Give you some examples of what an action error is. But I want to get that word in your mind as you go through the case, action error. And for example, as the year turns, and for those who still write checks, you write the date of the check in January and you put the wrong year because you're used to doing 2001 all through the year, and it should be 2022. Well, that's an error. You're making an error you don't even think about. Or in computers, you change the password, but absentmindedly go back to your old password. Or if you've recently moved to a different location, you sometimes can drive back to your old location not realizing that that's what you've done. These are called action errors, and they are ordinarily dismissible, but they become quite important when what happens is catastrophic. And when someone makes a mistake and wants to do one thing but does something else with consequences of the kind that we see here. You know, action errors in the field of great catastrophe include airline mistakes that are historically made, why a high-time pilot would suddenly miss a landing after 30 years, why a surgeon perhaps after 1,000 surgeries might make a mistake, which can happen, or a diagnosis may be missed in the time of stress. Action errors in police work, Dr. Miller will tell you, occur in times of chaos, acute stress, when the decisions have to be made in an instant, when there is no time for reflection, and where the individual involved is in turn chaotic and perhaps intoxicated. Stoned is another word for it. It's up to you, of course, whether action error occurred in this case, and he's not going to give you an opinion one way or another, but he'll explain what happens to the brain and what happens in these high catastrophic instances is that the habits that are ingrained, the training that's ingrained, takes over in these chaotic situations, and the historic training is applied and the newer training is discounted. And the evidence in this case is that the tasers were only available in the last 10 years, and this is a brand new taser, whereas by comparison, Ms. Potter has had 26 years of gun training. And an error can happen. We are in a human business. Police officers are human beings. And that's what occurred. At the conclusion of the case, I will rest and we'll get a chance to argue for what the facts show. And that will be an argument for your verdict of not guilty. Ms. Potter's good name has been besmirched by this allegation, which is not true, and by the press coverage, which has been slanted, and we seek to reclaim it. And reclaim it we will. And our request for you to find her not guilty will be well deserved.
All right, members of the jury, we're going to break for lunch, and we'll start up again at 1:30. Okay? So have a good lunch.